Welcome back to another episode of Case of Interest Kohberger. I'm Newswatch 16 Stacey Lang. You'll see that I'm joined by one of our digital reporters, Joe Kohut from Newswatch 16. Thanks for helping us out on this project.
Oh, pleasure to be here.
One of the reasons why I wanted to bring you in and lend your voice to this project is that we're going to start to have a lot more to talk about as we progress towards trial, which again is scheduled for August, the Brian Kohberger trial in Boise, Idaho. And one of the reasons why we're going to have a lot more to talk about as we progress to trial is that the judge made a kind of an interesting, is ruling the word we want to use here?
Yeah, I think that would be a fair statement. The judge in this case has issued an order sort of clarifying the rules moving forward for filing, for issuing filings under seal, which means reports and documents that would be kept from the public view moving forward for this case.
Mm-hmm. And that is something that we see a lot of. I want to just take you to the Case of Interest landing page. And I know some of our viewers spend a lot of time on this page and are probably just as excited as I was to see that there has now been an official Brian Kohberger landing page on the Case of Interest site. And they're now listed in chronological order with the newest documents on top. Makes it a lot easier to read. But I'm just going to scroll through quickly. I mean, just, a ridiculous amount of filings in here. And if you go through and read every single one, you can see how many of them are orders or motions to seal. And Joe actually took the time to count them for 2025 so far.
Just in the first 5, there have been 39 different orders to seal, and a lot of that is probably stuff that you would expect to see, where it would be maybe witness lists or exhibits. But the judge in his order took time out to say that this is calling it a pervasive practice of filing material under seal, and that they need to weigh the countervailing differences between the public's right to know what's going on in their courts and the need to protect the integrity of the case. And it seems to be leaning too far into one direction.
Mm-hmm. Which is interesting because as two people who have covered only Pennsylvania throughout our journalistic careers, we have a lot more access to court filings, or at least they're easier to find in this case in Idaho court than we do in Pennsylvania. So far, this has kind of been a treat as far as access goes for us. And it looks like we're going to get even more.
It's interesting that you say that, because it's on the one hand, yes, it is easier to access them in the sense that it's easier to just sit down at your computer and access them rather than having to go to a courthouse and ask for the individual file. But it also seems to be more difficult to access them because so much of it is not accessible. You can access the link online to get to an order that seals the actual arguments that are being made in the case. And with this clarification from the judge, it seems that we're going to be getting to see a lot more of the so-called meat and potatoes of the arguments that are going on behind the scenes so far.
Mm-hmm. And we've gotten some of those meat and potatoes just in the first few days of this filing. I want to, because Joe noticed this as well, I wanted to pay attention to this footnote in this filing. I had an attorney tell me years ago to always read the footnotes, and then you beat me to it reading this one. It says, likewise, the parties seeking to seal a document that contains the entirety of the information sought to be sealed in the title of the document is an exercise in futility, because the name of the document, which contains the sensitive information once filed, is on the publicly available register of actions. We saw this play out last week. When a filing was posted to the Case of Interest site under seal, but the title said, I think I have it right here, motion to strike death penalty, RE autism spectrum disorder. And just about every media outlet in the country saw just that title. That's all we had available to us. And then made boundless assumptions about what might be in it. And we were discussing it. We decided on Case of Interest not to talk about it, but ever since this filing, and we can say that it might be because of the judge's ruling as related to secrecy, or it could just be a coincidence. We now have the details of that filing.
It's interesting that the actual motion itself was filed under seal, but the judge's order regarding sealing of paperwork, it says that we are jumping too soon into automatically just filing things for seal rather than seeking less restrictive ways of protecting confidential information like redaction or using initials to identify somebody rather than their full name. And this particular motion that you're discussing seems to lean into the redacted issue. Some aspects of it are indeed redacted. Some exhibits are indeed still sealed, but we can at least see what the arguments are that the lawyers are making for why the death penalty should not be considered in this case because of his health diagnosis.
Mm-hmm. At this point, we're talking about motions to strike death penalty. We talked just you and I off camera about the motions in limine. We're really heavy in the pretrial motion part of this case, right? And that is something that typically happens ahead of trial.
Mm-hmm.
It's anybody's guess whether or not all of these things can be hashed out before we get to August, or if that means that they have to postpone.
Well, I mean, you want to have the fairest trial possible. Both sides want that to avoid any sort of appeal issues moving forward. So if they can't get everything done before then of course it would have to be pushed. But it's still March, so August is still a ways away.
Mm-hmm.
And based off of this March 3rd judicial order, we're going to get to see a lot more of what it is that's actually happening.
Yeah, I think it's going to be a busy few months for us.
I think so.
The filing about the death penalty and autism, it includes a lot of Supreme Court decisions that have to do with the culpability of individuals that have disabilities. Nothing specific about other than he has been diagnosed with ASD. Nothing really specific about Kohberger's diagnosis. This seems to me like an attempt when life is literally on the line, as it is for him. Any attempt to mitigate that is what his defense team's going to do.
They have to use every available means at their disposal in order to try to get the judicial system to spare his life. That's their job as his defense counsel.
Right. I like that you called it meat and potatoes. So we're going to move to the next meat and potatoes. Big piece of evidence that was made public. I think we can assume because of that March 3rd filing from John Judge.
Helped.
Yes. And it has to do with the admissibility of certain evidence on the prosecution side, and that is the text messages between the two surviving roommates. We know, other than the four people who were killed, there were two other young women in the house, and these are text messages that they sent to the four individuals who passed, and then between each other. And there are legal arguments in here about whether or not they are hearsay. And I don't see, in all of our experiences in trials, these will be admitted.
Most likely text messages usually are.
Right.
I'm not too sure how if the rules may play out a little differently in Idaho as compared to Pennsylvania. But I imagine that they probably will be.
Right. I'm not going to show all of the text messages because they do, show some expletives that I want to display on the screen. But there is, and it took me a couple of reads of this and the 911 call, which we'll get into, a couple of reads to try and figure out what's going on here. We do know, because of this filing, that these two young women are going to testify, are scheduled at least to testify at trial. And this is them trying to rouse the roommates that they have not heard from, and also communicating with each other. The one who we know, just from her initials, was on the main level and had eyewitness of the man that was in the house that night. Tells the other roommate about that person. One of the other things that has been now made public is, again, a redacted record of the 911 call from the next morning after the murders. And if you take, we'll include a link to these documents. If you take a look at it, it's attached as an exhibit at the end of the filing. It took me a few reads to be able to kind of get some grasp of what was going on here. It's a chaotic phone call without even hearing the audio, that I'm sure we'll get some context to it at trial. But it kind of helps. It paints the scene of several young people, who I think, like the rest of the public, when we heard about this, could not have possibly fathomed that what happened is what actually happened.
Mm-hmm.
There were a million different, more reasonable explanations for why those four individuals died that night, than what it actually was. And they're passing the phone around a lot. This is something that, this is a formal filing asking for the admissibility of this evidence, but there's a high likelihood that this 911 call will be played at trial.
Oh, there's almost certainly a high likelihood.
Yeah.
There's very powerful evidence that could be introduced that helps bring a jury to that moment in time and to that place, that helps set a scene for them and helps them, it transports them to that place.
Mm-hmm. And as far as the filing goes, a perfect example of what the judge is trying to lay out in that March 3rd filing, where this is valuable evidence.
Yes.
Um,
but this is also not new.
Right.
This was something that was filed how many weeks ago? Several weeks ago.
Several weeks ago.
Yeah. But it was filed under seal.
Mm-hmm.
And one of the points that the judge had made, that the parties had been leaning too heavily into automatically seeking the sealing of something rather than seeking a less restrictive way of protecting confidential information while also protecting the public's First Amendment right to know what their courts are doing. And in this case, a unsealed version was released to the public, but that was also redacted, in that it did still protect certain key bits of information, like the names of the people that were there in that house at the time.
Mm-hmm.
But the actual evidence, much more of it has been released to the public.
And I think if the last week is any indication, that's going to become the trend as we progress towards trial, that there is going to be more and more released publicly, but redacted. So we'll have much more to talk about. So I appreciate your insight for this episode of Case of Interest, and stay tuned. We'll have much more to talk about.